The issue of documentation is additionally at the core of Crouse's second issue concerning her request for the court to consider the applicability of the Texas Organized Crimes Act 71.01 TPC in investigating the pattern of racketeering activity, prompting this appeal, and to declare it as in violation of 21 U.S.C. Section 963. U.S. v. Williams, 809 F2D 1072, 5 Circuit, 1987, states, quote, because of federal government's treatment of marijuana, the RICO statute gives a person of ordinary intelligence fair notice that marijuana is included as a dangerous drug and would serve as predicate of RICO, end quote. While at this time controlled substances that are scheduled as prescription medications for medical treatment may not qualify as narcotics, this case shows how and why they are dangerous drugs as defined through the above referenced case and should therefore also be accountable to the laws that define narcotics and distribution of narcotics per 21 U.S.C. Section 963. These controlled substances do impact brain chemistry and also contribute to behavior modification. Without adherence to certain standards, habituation to the processes of acquiring, consuming, storing, and distributing such controlled substances can contribute to the proliferation of criminal activity in much the same manner as do those controlled substances classified as narcotics. These controlled substances are distributed through hospitals wherein they are originally prescribed, and shelters that refer or demand that persons residing within acquire a mental health assessment with attendant treatment involving controlled substances. The prescription itself creates a number of economic variables that can and are assigned to others to whom the hospitals and shelters refer persons in an effort to acquire additional resources. Programs requiring the acquisition, consumption, on-site storage, and/or distribution of controlled substances and that are engaged in experimental behavioral economics testing must therefore be held accountable for the means by which persons acquire, consume, store, and distribute controlled substances. This accountability requires caution in assuring that controlled substances are acquired, consumed, stored, and distributed correctly, especially considering that the intent of habituating persons to patterns of resource acquisition, consumption, storage, and distribution are inherent in the process of participating in behavioral economics testing modalities. At the least, this obligates providers to adhere to appropriate procedures so as to assure that the distribution of these controlled substances through referrals is not a criminal act. At most, it compels administrators to exercise vigilance to assure that they or no one from whom they receive economic or other benefit through the assignment to others of economic variables associated with the prescription of controlled substances are engaged in a conspiracy to commit a crime or are actively participating in a criminal enterprise. That's directly from my writ of habeas corpus that was submitted in July of 2017 as an appeal from the civil court where I had requested an in-bank review of a petition for the exercise of the court's plenary powers because my appeal periods have been intentionally manipulated and missed by the State Bar of Texas and the Texas Medical Board. And by the way, I now know the State Bar of Texas literally manipulated its responses to my efforts to contact them about grievances concerning attorneys barred with the State Bar of Texas in two major correlations with the Department of State beyond their jurisdiction, but nonetheless it seems a priority and has to do exactly with what is mentioned herein. Now, we're at this point we're at where I understand that after a certain amount of time, the opiate epidemic in the United States, rather than being addressed as a matter of criminal distribution of illicitly acquired narcotics that were classified as controlled substances. Civil cases were allowed to be bought in certain states that gave monetary awards and provided metrics associated with those companies that they could recirculate into their business operating plans, especially if there was already a predetermined effort to begin to take business from the gas and oil sector and to re-engineer the economy for a different kind of capital investment in the derivatives market, specifically around pharmaceuticals of one sort or another. Right? That was the kind of leveraging that was going on rather than approaching this from what it is: criminal activity being aided and abetted in an understanding that people's habituation to patterns of distribution in the course of behavioral economics testing is also going to teach them the economic incentive of keeping your mouth shut when they start smuggling a couple of pills here, and keeping your mouth shut when they start, I don't know, maybe smuggling a couple of other things from the hospital they weren't even supposed to have, to, I don't know, maybe smuggling out biologics. I don't know, maybe smuggling out credentials for somebody that's in the process of trying to acquire a patent. I don't know, maybe smuggling out actual people. I don't know, maybe using your medical distribution outlets to smuggle weapons. I don't know, maybe using the weapons you're smuggling in those medical distributions outlets in order to smuggle hardcore drugs, up to and including big bricks of hashish or maybe even opium. And it's exactly what they've been doing. And in the course of that, they've also been developing a cover up of breaches of appropriate grievance processes within the respective milieus in an effort to extort people with ever increasing levels of risk on one hand, and then to also normalize people to mischaracterizations for the purposes of intentionally defrauding insurance by calling biological attacks and biological weapons promulgation a health pandemic. And that's exactly what I just was trying to bring into the fore. I'd watched it for a year escalate to the level where they were literally framing homeless women, or that were made homeless because they had been beaten by their husbands, so they had to go to a shelter for assistance, and they were framing women because they wouldn't deal drugs, illicit drugs, while they were in the shelter, denying them any process, sending them back to their abusive husband in completely racialized schemes. And then trying to normalize people to electronic weapons testing, and telling them, if you want to keep your kids, then you have to be compliant with shelter policy, and that means you have to go get a mental health assessment for your overactive kid. And now we're talking about using, leveraging, and hedging on the rollout of the 5G network to speculate on specifically predetermined announcements of metrics within a global schema identifying deaths or casualties per day in specific locations. It's what they call predictive programming on one level. And another level, I think it's what they call econometrics. It's mass murder. This was never meant to be a weapon. This was meant to be protection. This was meant to be security. This was meant to be a deterrent. It still is. Part of this is understanding assignment of economic variables. Now's the time to reassign the economic variables here. This is meant to secure criminal prosecutions of people aiding and abetting criminal drug enterprises. The Kingpin statute applies, but so do numerous laws regarding financing acts of domestic and international terrorism. Understand, that is what the state of Texas is trying to float tonight. They didn't do their job in prosecuting these crimes. They did something else with it. They aided and abetted an illicit distribution network, as evidenced by the fact that they literally had to wipe out their entire electronic filing database overnight. What are they trying to do to characterize or calibrate this while they're redistributing it, along with whatever other legal filings have been put through the Texas Supreme Court, at least since the end of November of last year? I really hope you're not trying to route this through New York and apply any algorithms. I said 10 days, right? December, January, February, March, April, May, June, July. It's 8 months. 8 months. You know what that is? 2/3. Legal.